here? Right, perfect. Good afternoon, everyone. Thank you for joining us. I believe we have a very interesting panel coming up. We will hear 3 short presentations, and then we will have an open discussion. Our first speaker today is Professor Amichai Cohen. Amichai Cohen teaches international law and national security law at Ono Academic College and is a senior fellow at the Israel Democracy Institute, where he's the director of the program of national security and democracy. He's the author, with Stuart Cohen, of Israel's national security law, political dynamic, and historical developments.
Thank you very much. First of all, I must say, I must apologize. The previous act is a very difficult one to follow. I'm not sure I have the capability of doing it, but I'll do my best. I'm very happy to be here, and I thank the organizers for inviting me to speak. And what I want to speak today is about the role of law in national security and democracy discussions. Law, I will claim here today, is used in these discussions in a dual way, in 2 meanings. In one meaning, law presents a limitation on the power of government. According to this approach, the debate revolves around the optimal level of the use of law, assuming that law limits somehow the power of the government vis-à-vis infringing upon human rights, etc. What I want to claim here today is that law has a completely different meaning in the eyes of some. Law as an enabler, giving governments authority to do certain things and not limiting the power of government. And I think the discourse is changing here, and it's important to note it, and it has implications towards the way we teach law and towards the power of courts regulating the way the executive branch is operating in matters of national security. So I will present very shortly the classical view. The classical view, everybody knows, there is a discussion whether law is even important in matters of national security. We all know Cicero's, right? In times of war, there are no laws at all, and not even not this extreme position, but Justice Rehnquist wrote that the laws will thus not be silent in times of war, but they will speak with a somewhat different voice. And Justice Aaron Barak, in a very famous article at the Harvard Law Review in 2002, wrote about the fact that law is important, especially in times of emergency and in matters of national security, because this is where human rights are in danger. All these think about law as limiting the authority of government, right? In times of emergency, in matters of national security, they all think about law as protecting human and civil rights in these times, and the discussion is regarding the optimal level of protection that law should provide during times of emergency and in matters of national security. But of course, this is but one way of looking about law. Traditionally, and here I would say perhaps prior to the Second World War, the way that law was conceived was as a way to giving governments authority. Common law, for example, protected certain rights, and then government needed some kinds of authorities that they didn't have in regular times, and so they needed law. What they did is they legislated powers that would give them more authority in matters of national security. I'll use a local example. Okay, so between 1917 and 1948, Palestine was controlled by the British Mandate. And in the end of the 1930s and the 1940s, there were riots here, both of Arabs and Jews, And what the British did is they enacted the defense emergency regulations. This is law, but it has nothing to do with law as we think about it in the first approach. On the opposite, it's a law that gives the government certain authorities. So, for example, military censorship, the right to demolish houses, the special courts. All these were created by this law. So this is traditional. But we thought that I think the second half of the 20th century, the time I went to law school, and perhaps some of you went to law school, was that law is something that's connected to the general principles of the system, right? It represents general principles. It's something interpreted by courts, which are usually liberal courts, so they put some balance on the power of government. So we have laws like in Israel, 1979, the law, the administrative detention law, which limits the power of administrative detention and judicial review over administrative detention. This idea that some powers of government will be somehow limited if courts would have judicial review. And I think in the United States you have the FISA courts, right? The whole idea that somehow listening and infringing upon the right to privacy will somehow be corrected if you have some judicial review over it. And so a more liberal approach toward law. But of course the idea that law is an enabler that law gives government authority was always there, and it re-emerged after 2001 in the last decade. We have it in the United States in the USA Patriot Act, we have it in Israel in the Counterterrorism Act, we have it all over the Western liberal democratic countries where the executive branch started thinking about law in the older way, law giving it authority. And actually, and I don't want to take too much time, I think there is an institutional aspect here. So the question is, who controls the use of powers of the government? So clearly, in matters of national security and in times of emergency, the government needs more power. But we have, this is the eternal question of a liberal democracy. How do we create security institutions strong enough to protect our democracy from dangers without, but not strong enough to revolutionize our democratic society from within, right? So this is the dilemma. And the idea was that courts are a good way to control the powers given to the executive. This is the liberal, I think, approach. This is a very problematic approach. First of all, it's problematic from the point of view of the executive. The executive does not like courts controlling it, and it does what it can to evade this control. And since the executive has become sophisticated in, I think, using the legislature in order to attain more powers, it also attains more powers in the sense that it does not like judicial review over what it does. So what do you do? How do you evade judicial review? There are techniques. First of all, you use very clear language and you give yourself very wide authority, and you do not put very strict procedures within the law, so you can evade some kind of judicial review. Second, there are real problems in courts controlling the powers of government in matters of national security. This is not only manipulating the issue. Objectively, there are problems when courts deal with matters of national security. The Israeli Supreme Court undertook an experiment. I call it an experiment because I think it has never been tried by any national court before. Perhaps the European Court of Human Rights in some aspects, but no national court has ever taken upon itself to to intervene in matters of national security, as the Israeli Supreme Court has done from 1995 to 2012, something like that. There is no equivalent example. So you have a court intervening online in times of a military operation. When an actual military operation is occurring on the ground, you have a court reviewing what the powers are doing. You have a court saying to the IDF that certain operational doctrines are illegal. You can't use certain operational doctrines. You have a court allowing almost everyone to petition the court, no standing, no justiciability, no limitation. Everybody can come to court with these claims regarding national security. It's an experiment. I don't think it's a successful one. Not in the sense that I want to criticize a specific decision, but the idea that you have a very strong executive which is in conflict and which uses its power. It's not national security powers like in Germany that they are somewhere, you know, in a drawer and you almost never use them. But it's actual. It's used daily. The idea that the court would be successful in controlling the executive, I'm not sure. It was a great success. Is there an alternative? So I have two points here. I'll do an interim summary, just in case you had a long day today and you're already. So the first one is that the nature of legislation has changed from a legislation trying to limit the executive to a legislation giving the executive more power. And the second is that the idea that courts are the best tool that we have to control how the executive uses its power was not very successful. There was a time. So, for example, Eyal Ben-Venisti claimed in a very famous article, Reclaiming Democracy, that courts would somehow block the powers of the executive. And I don't think it proved correct. And once again, I think there are reasons within matters of national security why it can't be. So national security requires very quick decisions. We don't have time for very long procedures. It can't be completely transparent. And this is completely against the ethos of courts. Courts are transparent. By definition, this is the idea. The court should be transparent, the court discussion, and you don't have the possibility to have it in national security matters. There are other reasons why. We have an alternative, an emerging alternative, and an alternative which I think the best example is in the United Kingdom, where you have a commissioner for the investigative powers of the government. It's once again an experiment, an idea that in order to control the powers of government, what you need is to work from within the executive, independent commissions within the executive, not external courts, but within the executive. You have human rights commissions in certain countries where the public is involved in some level of decision making. So we see some alternatives emerging. So I don't want to be pessimistic here. It's not like there is no solution, but the solution has to take into account the fact that the executive has we used to think in national security of like a competition over powers, right? Like in the War Powers Act, right? You have the legislature, is it able to control the executive? I think what happened in the past almost 20 years has proved that the executive has won this competition. I mean, the executive is responsible for this. It's, I mean, we might not think it's the best solution, but this is what happens. And in almost every liberal democracy, this is what happened. Perhaps, once again, Germany is a somewhat outside. So you have some legislative mechanisms of control, but these are relatively weak. And courts, as I said, we have to think about mechanisms which work from the executive in order to control this trend of executive power. That's it. So I think
Thank you very much, Amichai. Our next speaker is Itamar Mann. Itamar Mann's main area of research and teaching are international law, refugees and migration, and national security law. He's a graduate of Tel Aviv University and has LLM and JSD degrees from Yale Law School.
Thank you very much for inviting me. Thank you for the comments by Professor Cohen. My own comments will, to some extent, be a continuation of the same topics. However, I think I will tell a slightly different story, a story that, if I may already point out the main difference, I think it will be a story about a continuum between the national security role of courts in the intervening period and what we see today as a seeming collapse of the national security courts. And I want to focus particularly on the issue that was called in the United States enhanced interrogation, much discussed, of course, torture, and my comments that I would like to propose to you today come at the heels of the appointment of Gina Haspel for the director of the CIA. My contention is that, to some extent, what made possible this appointment, apart from the obvious political environment in the United States, is a particular setting of national security law, a particular set of assumptions in this area that Israel has a deep role in creating. The story starts, and that was my introductory comment, and so I'm going to dive into the actual talk now. So the story starts in 1987 in Israel, when a committee called the Landau Committee was put together in order to review what was then starting to be revealed as a practice of physical pressure on people being interrogated in particularly the context of the occupation in the West Bank and in Gaza. Very famously, this commission found that Israel has, in fact, been interrogators have been using physical pressure since the occupation began in 1967, and furthermore, that people being interrogated about this in courts, namely security officers, were lying when they said under oath that they have not been committing such pressure or inflicting such pressure on detainees. Now, against this backdrop, in 1999, Aaron Barak makes one of his most celebrated judgments, one of his most celebrated opinions, that upheld the prohibition of torture, both due to basic law dignity on the level of domestic law and on the level of international law in terms of the prohibition of inhuman and degrading treatment, cruel, inhuman, and degrading treatment, and torture. And Richard Goldstone writes later about this opinion. Few countries, much in the way that Professor Cohen spoke, few countries have suffered more at the hands of terror attacks than Israel. The response of the Israeli Supreme Court to torture has, however, remained uncompromising. Now, in an article that I published with a co-author about 7 years ago already, we tried to put a dent in this celebratory story. And the way we do that is, first, the kind of familiar aspect is the issue of the necessity defense. I'm sure that whoever of you has any background in this area knows about the necessity defense, namely the idea that ex post, after an interrogator has used physical pressure, they may be protected from criminal prosecution due to a justification based on the fact that they have saved lives. More importantly, perhaps, we pointed to what we call the application clause. That this is a particular clause of the decision in which Aaron Barak basically says that the Attorney General, Eliakim Rubinstein, at the time, has the permission to instruct themselves on the question when would they decide not to prosecute individuals that have used physical pressure during interrogation. And that was, the effect of this was really dramatic. A month, more or less a month after the decision, Eliakim Rubinstein indeed writes a memo describing how he will proceed in terms of prosecuting individuals, and he basically reverses the no ex ante authorization that is very important in terms of the way Aaron Barak's decision was understood, and says, and puts in place a set of ex ante bureaucratic rules that an interrogator would have to follow if they would then presumably later enjoy a defense of necessity that would defend a defense of necessity under the original Barak decision. So what we have here basically is a movement from an authorization in the Landau Committee, an authorization to use physical pressure during interrogation, to a world in which there is a kind of policy of unprosecution. The fact is that, to a lesser extent, physical pressure in interrogation in Israel has continued after this decision, and virtually no one has been prosecuted in a criminal court, and interrogators have been enjoying this necessity defense in the new bureaucratized version that Eliakim Rubinstein had put in place. So this is basically the outline of the Israeli story. The question now, of course, becomes how does this influence, what does this have to do with my introduction to these comments? Why had it any effect in terms of when we think about the United States? And here I think the point is really threefold. So first, even before the 9/11 moment, we have a kind of more academic influence going across and kind of learning from Israel and introducing proposed policies in the United States, famously led by Alan Dershowitz at the time with his idea of the torture warrants. But this is really just, I think, relatively minor, because what happened after 9/11, and this first became known in the famous John Yoo and J. Bybee memos, is that legal professionals in the executive branch went to the Israeli government, Israeli example that was understood as prohibitory at the time, to use it precisely in the terms that Cohen describes to us, namely as a permission, as an authorization. This was done first in the memos that were early exposed in conjunction with the famous ECHR case regarding Ireland. And then later, the Senate Select Committee exposed, among others, a draft memo from really a month after 9/11, in which legal professionals in the OLC they discussed the necessity defense, and they really refer to the Barak decision and how it had been implemented in Israel, and they really kind of actively engage in an expansion of this doctrine in order to provide a version for it of it that would be in service of the U.S. administration at the time. Now, we know that when Obama came to office, there was a lively debate about the question whether interrogators will be held criminally or otherwise accountable from during the Bush era. And we know what the result of that debate was. They were not. And here we see another movement, the same movement that I have identified in the Israeli context, from a kind of authorization during the Bush era to a policy of unprosecution in the Obama era that is really reminiscent of the development in Israel a couple of decades earlier. Now, when John Brennan, the previous CIA, the head of the CIA during the Obama era, was questioned on this during his appointment hearings, he was very he was pushed on this issue because he was also in service during the Bush administration. So would you actually engage in waterboarding again? And was waterboarding legal? And his answer is a very interesting one in the sense that he says on a kind of personal, private judgment level that he believes that waterboarding is reprehensible. But he also says on the legal level that the lawyers at the time had told him that it is legal, and then during the Obama administration, lawyers started to tell him that it's illegal, and in the future, facing alternative administrations that will perhaps emerge, he will again follow the lawyers on this issue. So there's a bifurcation, a deep bifurcation between the legal judgment and the moral judgment on this issue. Now we re-arrive at the present moment, and we have another head of the CIA who has been even more actively involved in the enhanced interrogation program, and as has been much discussed, is also engaged in destroying evidence of what she has done in that time. And I think this is really, taking even one step further, the same movement from an authorization to a moment of unprosecution, and then the complete lack of accountability for this thing, if it is indeed supposed to be prohibited, that is the outcome. So I think in the bottom line, we are left with the question: is there any difference between these two options? An option in which something is prohibited and not prosecuted, and one in which it is openly authorized. Now, I think this has a more theoretical takeaway that has to do with the role of comparative law in this context of national security. When the United States initially in the Bush era decided to go to a number of comparative contexts, they turned kind of naturally to what were then understood as other liberal legal systems that had confronted comparable problems. And the UK and Israel really emerge as the main important examples here, I think. And in both contexts, the enhanced interrogation or the torture, whatever you want to call it, emerges in a deeply illiberal context. So in Israel, you want to think of, we can think of it as a liberal democracy within its own 1967 borders. I think it's much more arguable and much more hard to make the argument that outside the 1967 borders, it still functions as a liberal democracy, and the torture or the physical pressure on detainees was taken precisely from that context. And so, similarly in the UK, the examples are taken not only from the deeper history of colonialism of Britain in various parts of the world, but also from the way the UK had conducted its last colonial war, if you will, in the context of the Troubles and the conflict with Ireland. So when one turns to these contexts, this is the kind of more theoretical or general takeaway, one needs to look not only at a kind of face value judgment of a system being a liberal system, but also to look at the way the legal powers are actually used, and also to the details of the system of government. And in both contexts, we see that it was hard for especially Israel to move away from these techniques as long as the underlying system of government remains in place. And when we return back to the United States and ask, has the United States really moved on from that post 9/11 moment? I would say that the fact that we are now confronting what commentators have called a forever war, or an endless clean war in another formulation. I don't know if it's so clean. The same kind of dependency is also imported into the system by using systems that became dependent, in fact, on techniques that were thought of as illegal. Thank you.
Thank you very much, Itamar. We're moving to our third speaker today. Professor Gad Barzilai is previous dean of the faculty and is now the vice provost. Professor Barzilai is a professor in the University of Washington and published extensively on law, politics, and society.
Yes. Just to say, Maya is part of our Minerva Center for the rule of law under extreme conditions. So we have a center in our Faculty of Law which deals with emergencies and exceptions. And I would like at the end of my paper maybe to